Welcome to this year's FOIA Bootcamp. My name is Michael Linhorst. I'm a lawyer and a fellow at Yale Law School's Media Freedom and Information Access Clinic. And the clinic, as well as the Floyd Abrams Institute for Freedom of Expression, is pleased to put on the FOIA Bootcamp. We typically do this every year. Unfortunately, last March, it was canceled for the pandemic, so we're excited to be able to put it on again and to have two fantastic panelists to be able to speak with you all about FOIA. Our panelists today are Mark Walker. He is the Freedom of Information Act researcher at the New York Times, where he oversees the paper's information requests. He's also a board member of Investigative Reporters and Editors, IRE, where he previously worked as a training director. In that job, he traveled across the country to help news organizations optimize their FOIA requests. Before that, Mark was a watchdog reporter covering law and order at the Argus Leader in Sioux Falls, South Dakota. We also have Anne Weisman, who's known as a FOIA guru. She was the Chief FOIA Counsel at CREW, Citizens for Responsibility and Ethics in Washington. She also served before that as CREW's Chief Counsel, and she was an attorney at the FCC and at the Civil Division of the Department of Justice. So Mark and Anne, if you could turn on your cameras and we can get going with the panel. This is going to have basically three parts. First, Mark will talk about the basics of FOIA, how to write an effective FOIA request, how to make sure you're targeting the information that you want to be targeting, and then the different administrative steps going through that FOIA request. And then Anne will talk about what happens once you get to the end of the administrative steps and you're ready to file a lawsuit. Now, I see Mark and Anne are having trouble turning on the video, so let me see if I can do anything about that.
Michael, I think it's you that has to turn them on.
All right, let's see. I'm not seeing an option, actually. Sorry, bear with us for a moment, everybody. Hi, Anne.
Hello.
Sorry for the video troubles, and Mark is with us too. All right, so with that, I think we're about ready to begin. So as I said, Mark will talk about FOIA Basics, how to write an effective request, get the information you're looking for, and then pursue that request up until it's time to file a lawsuit if that becomes necessary. And then Anne will talk about what happens once you're ready to file a lawsuit. We should have time for questions at the end. Feel free to add your questions to the Q&A you should see at the bottom of your screen. And then I'll direct the questions to Mark and Anne at the end. You can also ask the questions yourself on video. Just raise your hand and I'll call on you once the time comes. But now I'll turn over to Mark and I will operate the PowerPoint. All right, and you should be able to see Mark's PowerPoint now.
Hi, everyone. Like I said, my name is Mark Walker. I'm the reporter and FOIA coordinator for the Washington, D.C. Bureau of the New York Times. So I oversee all of our requests, sort of writing them, helping write some of the appeals. If someone's tripping up and struggling to get the request, I talk them through that and help them help collect as much documents and data for the Washington Bureau and for the entire paper as I can. Next slide. So just a quick overview of FOIA. So the good, we're going to talk about who can use FOIA, what can you FOIA, how can you FOIA. We're going to talk about the bad, some of the FOIA exemptions, the ugly, how the system is broken in some cases, making a request, after the request, state requests and FOIA as part of reporting, and sort of tips and resources. So to start out, FOIA was implemented by President Lyndon B. Johnson. This legislation springs from one of the most essential principles: a democracy works best when the people have all the information that the security of the nation permits. No one should be able to pull curtains of secrecy around decisions which can be revealed without injury to the public interest. That's ideally how the spirit of FOIA was started, but as we all know, that is not how it usually plays out. And that's why we go to court. We spend a lot of time, talking to FOIA officers on the phone, making negotiations, studying the law, refining our request over and over and over to actually try and get through some of these curtains of secrecy that have been pulled up. So the Freedom of Information Act, Federal Freedom of Information Act, provides access to existing records held by the federal executive branch, their agencies. FOIA reflects a philosophy of disclosure and requires the government records to be made available unless statutory exemptions apply. FOIA, unfortunately, does not include Congress, the courts, and the White House office. As an example, the president and his aides. There's some branches of the White House, like the Office of Budget and Management, that are, they can be FOIA'd, but for the most part, the majority of the White House is off limits and cannot be FOIA'd at all. There are some state and local agencies that are covered by state public records laws as well. So what can you FOIA and how? You can FOIA any agency record, any record that an agency has or maintains. Something I like to do to help study this is I ask agencies for their record retention schedules, which is basically a menu of how what records the agency has, how long they keep them, do they have a destruction date? If so, when that is. A lot of these records are really detailed down to keeping track of how much laundry soap an agency uses to clean uniforms, how much money they spend on cleaning supplies. So it's a really detailed breakdown of all the records that an agency will have. FOIA applies to, means the agency has created or obtained records, is under the control of the requested material at any time the FOIA request is made. The agency has no obligation to make records for you. It is very important. They can, if they would like. We run into this a lot of times with data that we get through FOIA, to where we will ask the agency for a specific breakdown of information or certain types of information to be put in the spreadsheet, and they will usually push back against us and say, we don't have that information in that form. Because we do not have the information in that form, we're not going to make it available to you. So they will deny the request because they are no obligation to create a new record. They can if they would like, which gets to some points I'll make later about sort of FOIA diplomacy. So the bad, there are 9 FOIA exemptions that you'll run into that the agencies like to use. Exemption 1 is one I see a lot when I'm filing, FOIA requests and requesting documents from the CIA, the FBI, the NSA. A lot of times they will, give me a sort of a GLOMAR response. We can confirm or deny the existence of these records. They will say records are classified. There's other avenues. FOIA is a great avenue, but there are other additional avenues to sort of pry loose classified information. Exemption 2, information related solely to the internal personal rules and practices of the agency. It's not really one I see or deal with a lot. Exemption 3, information specifically exempted from disclosure by another statute, which basically means there's other federal rules or laws that prevent this from being released. So we're going to use this exemption to not blanketly release this information to you. Exemption 4, trade secrets and privilege or confidential commercial and financial information. Unfortunately, I worked for the paper who lost the Supreme Court case that sort of strengthened Exemption 4 in the Supreme Court recently. But basically any sort of like businesses, the case that we were, took the Supreme Court involved food stamps. So basically we wanted to get the data on food stamps to look at trying to find food deserts. And the case was won, then appealed. And there were all these other companies who submitted briefs saying that, if this information, this food stamps information was released, this would violate, commercial, confidential commercial, provide financial information that would make them less competitive. And ultimately, the Supreme Court ended up siding with them. Exemption 5 is, I would say, the exemption I see the most. It's the most like overused exemption. It's the most abused exemption, in my opinion. It's interagency and interagency memos or letters that would not be available by law to a party other than an agency in litigation or with the agency, like attorney-client privilege, working documents. But the issue with this, and one of the things that we see fairly frequently, is that this is sort of the, I'm withholding the information because I really don't have a good reason to withhold it. So I'm just going to blanket it Exemption 5. Usually when there's sort of embarrassing information about an agency or information that would, paint them in a bad light, a lot of times they sort of use this try and blanket catch-all exemption of Exemption 5. And that's probably the one I encounter the most throughout my work. Exemption 6, personal and medical files and similar files, the disclosure of which would constitute a clearly unwarranted invasion of personal privacy. I see this a lot, and usually just sort of redactions of email addresses or personal phone numbers. Like I'll get some documents and it will be from the Secretary of HHS, and he's sending some emails, and in his signature he has his personal cell phone in there. A lot of times that will get exempted out. For the most part, I don't see this usually used to prevent the release of documents. Right now, the times we do have a lawsuit against an agency who is using this to protect a medical review. But that's probably the most egregious case that I've seen or have worked on. But mostly it's redacting out any upcoming doctor's appointments and phone numbers and email addresses and things like that. Exemption 7, records or information compiled for law enforcement purposes, but only if disclosure, and I have these disclosures, different types of disclosures. A lot of times they will say that this will, interfere with, law enforcement investigations, law enforcement proceedings. It's an unwarranted invasion of personal privacy, would identify a confidential source, different things like that. And there are different arguments that exist to get around this exemption, but this is probably the second or third most exemption I run into. Exemption 8 and Exemption 9 aren't really exemptions that I've ever come across in my FOIA work as a reporter, but put them on there just to show these are the other two exemptions that typically are used by agencies to prevent the release of information. So the ugly, this is just sort of a breakdown of when I talk to reporters and I'm writing requests, I'm like, okay, there are some agencies that are great and they turn records over, incredibly fast. One agency I often work with that turns over records fairly quickly is FEMA. And with FEMA, I have a good working relationship with them. Sometimes they turn it over within days to weeks. But, with the CIA, I get put in this expedited processing category, as you can see, has shorter turnaround times. But even for them, I'm like, what does, I've never not been awarded expedited processing, but that usually means like, hey, it's not going to be 15 years, it'll probably be 7. And so this is just something you think about when you're crafting a request, because it goes into 3 buckets: the simple, complex, and expedited processing. And I tried usually aim for my request to either go in the simple bucket, or I try and make an expedited processing argument, just because you see just the difference in the average number of days I have highlighted on when you get a request in the simple bucket, when you get one in an expedited processing bucket, and when you get something complex. There's just some offices that just take years to get records for. Reporters aren't, usually reporters and lawyers aren't the highest users of FOIA. A lot of businesses will file FOIA to try and get information. You have nonprofits, news organizations, and law firms make up a small percentage of the requesters who use federal FOIA. So you can see the system isn't usually clogged up by us, it's clogged up by other outside agencies who are using it. So before I file a request, one of the things I think through is like, okay, what am I looking for? Because FOIA applies to documents, not information. If I'm looking for a piece of information, I go to the press person, or I try and research some documents. So I try and sit through and at the beginning think, okay, if I'm a FOIA officer in a particular agency, what would I need to go find this information? So it's kind of like just writing a step-by-step guide is kind of my approach of like, if I want someone to go get a piece of information for me, here's like step 1, 2, 3, 4, and 5 on how to do that. So I start by, completely understanding what I'm looking for. I check the websites, check reading rooms. I try calling the agencies to get information. I do my homework to learn as much about the records as I can and learn maybe specific names of reports, documents, the name of a database, how it's kept, because those specifics and those details really can be the difference between getting something and spending a lot of time and ending up with nothing at all. Be specific, be clear, be human. The person who's like trying to process this request is a human, and I try and make sure that like, if that were me, like I would want someone to like just treat me like a 5-year-old and walk me through what exactly they're looking for. And that's what I do. I go in with patience. I try to be as clear and concise as possible. The request must reasonably describe the records. So it's basically for any professional employee of the agency who's familiar with the subject area to be able to find and locate the records. You can't ask questions. You can't make broad sweeping requests. You can, but it is frowned upon because unless you're going to probably straight litigation, it's going to take a while just by the waiting FOIA process. When I say be specific, you can use things like keywords, list the name of custodians, date ranges, email addresses, and things like that to help walk that FOIA officer and be clear and concise in your request on what information you're looking for. And here's an example of a pretty clean FOIA request that was put in that we ended up litigating at the times of, in quotes, saying that what we were looking for was the factual evidence. You know, those are some of the key words that when we're filing the request and like make the difference. Because I've filed requests like this before, and the person who runs the agency says, "I don't know what you're talking about. I have no idea. I've never heard of that." So I try and like in parentheses upfront tell them exactly the name of it, when it was, how many pages it is, any information that could be put up, just providing it to that person. Key components of my request I always put in is sort of the format. One of the things that I hate is getting a massive response back and it's all like PDF'd. And I often argue with like the agencies like, well, this is the only format we have it in. I'm like, Microsoft has never created PDF. Google has never created PDF. You took this document and you turned it this way. I've had agencies who will print off a spreadsheet, scan it in as a PDF and then email it to me. And I'm like, this is clearly a Excel spreadsheet, and that's what I would like. So I always try and be very explicit in my like requests on like the format in which I'm seeking the documents. Always try and ask for a response time, any sort of estimated response time. I cite the response time they have to get back to me, and I try and also ask them when they think they can reasonably get these documents so I can start planning and mapping out my strategy from there. Always ask for a fee waiver. To just have the federal fees waived it's something just pretty standard across the federal government. And expedited processing, this is where I spend a lot of time doing my research, just sort of like studying what each agency has sort of a different standard on how they award out expedited processing. So I spend time researching what that is and crafting and writing an argument to fit what they're looking for to get my request into that expedited processing track. The timing and principle, the agency must make a determination within 20 days. They usually take a lot of extensions. They respond to you and say, hey, we've got this, and then you won't hear back from them, you know, for a while. So I always make it a point to check in and again, ask for this estimated date of completion, which is something I put in my calendar to sort of like in the morning ping me of saying, hey, they told me this will be here this date, probably should follow up and see where it is. We talked about the format. The format of records must be produced in any form or format requested by the person if the record is readily reproductively by the agency in that form or format. So I study, one of the things I look for is like, I will call the press office or I'll talk to the FOIA officer and say, what types of ways do you keep track of this information? If I'm looking for photos, I need to understand how they keep track of the photos. I'm looking for data. I try and understand how it's collected, how it's stored, over what period, what's the name of the program. There've been cases to where I've come across FOIA officers who have asked to, you know, export information. They said they can't. And I've called the company and say, hey, your program says you can't, you know, print or export. And obviously those companies have a reputation they want to uphold, or they're selling the software to the federal government and other government entities. And it's like, we can do something as basic as export. And I'll sit on the phone, I will talk to them, I'll write the instructions down, and I'll call the FOIA officer back and say, I've got some information. This is how you do this thing. And I've talked to this company and they say, oh no, this is 100% a way you can do it. So it just goes back to just trying to spend a lot of time just doing my homework and understanding every aspect, even down to how emails, like whether someone's using Microsoft Outlook, Gmail, or any sort of other email program, and understanding how it works and what the limitations are. Fees, we touched on fee waivers and fee categories just for representative of the news media. I can go to the next slide. So expedited processing, the agency must make a determination on a request for expedited processing within 10 calendar days. If the agency grants expedited processing, it must be processed as soon as practically possible. The two bases that we see a lot is failure to obtain on an expedited basis could reasonably be expected to pose an imminent threat to the life or physical safety of an individual. Also, another one we see is with respect to the request by a person primarily engaged in disseminating information, there is an urgency to inform the public concerning actual or alleged federal government activity. I know when I first started, I would get requests from, well, replies from reporters for different federal agencies, like, what, I wrote this expedited processing argument and like got turned down and it was really great. And I was like, oh, just send it to me and I'll take a look. And they would literally say, I'm a reporter at the New York Times and I'm writing about this thing and I need to inform the public about it. And usually have to go back and say, that's not a real argument. Like that you didn't say anything. You didn't make any argument at all. And I try and explain to them like, this is what you do, or I help them craft these arguments so we can get this. You know, there's been cases to where I've got the recommendation of, you know, folks inside the agency to give me expedited processing and wasn't awarded. So it's not something that like, even if you make the best argument that you're guaranteed to get, but it just helps your case. Ways I do is I tie requests to concrete events in the near future. I will tie it to, you know, maybe in the Capitol riot for a request, I've tied it to that event, tied it to, you know, the law enforcement trying to identify people. And I always certify that the statements that I put down are true, then I always appeal. To just wrap up, just to make sure we have some time for questions to go through this real fast. I spent a lot of time on the phones, talking to FOIA officers, getting to know them, understanding how long they've been there, you know, what types of things they see, what's helpful, what's not, and just building a better relationship with them. And I think it's gone a long way. And I think it's helped me a lot of times avoid sort of the lawsuit route. I negotiate, I narrow the scope of my requests. Sometimes I'll go in broad and then just sort of work down. I always talk to the agency, and if I know I'm getting a massive subset of documents, I'm asking them for a rolling production. Then I'll in some cases, get a lawyer involved. And a lot of times it's just really creative, just coming up with really creative ways of trying to like narrow down a request. I've, you know, worked with the Department of Interior on just giving me hit counts, a breakdown of all of the email addresses by hit counts. And I'm like, okay, I can see that, you know, for some strange reason, this guy gets a lot of emails from Target. Don't really want any of these because those are shopping things I don't care about. You know, he gets a lot of emails from Amazon, don't really care about those either. And sort of just like narrow it down that way to the actual subset of documents that I'm looking for. And if all else fails, I get the, you know, the FOIA public liaison on the phone and try and talk them and try and just better understand what the hang up and hold up is. And I'm going to pass it off to my co-panelists just so we make sure we have enough time for questions at the end.
Great, thank you so much, Mark. And that's actually a great segue because, well, I have a slide. I want to take one of my slides out of order. I think it's slide 6. I'm going to talk about litigation, but litigation requires resources. It's expensive, it's time consuming. You know, you need to find a lawyer typically who knows FOIA and FOIA law. So just to begin with some more tips on how to avoid litigation, really I want to pick up on a point that Mark stressed, which is show some flexibility. That's not the right slide. So we can just go back to the beginning and we'll skip it when we get there. Show some flexibility in what you're asking for and be willing to narrow your request. Now, especially with the pandemic, the biggest issue I have with FOIA, I'm not getting anything. Agencies are so backed up, and you really have to weigh the possibility to get something now that might at least lie at the heart of what you want versus literally waiting years. And one of the things that I've tried that sometimes works is what I call staging the request. And that means, I'll say, okay, I'll narrow now and I'll agree as a first step that all you have to do is this. And then if I'm happy, I'll go away and leave you alone. But I reserve the right to come back. Now, usually the agency will say, well, if you want to come back, you have to file a new FOIA request. And if I can't talk them out of that, I'm able to talk them into at least putting me to the head of the line. There is an administrative appeal process. I have to be very candid. I have had very mixed success. I don't know, Mark, if you've had better success, but it's worth taking advantage of. Agencies do change their mind, and that's another way to avoid litigation. And then finally, what I would say is there is an organization called OGIS, the Office of Government Information Services. It's part of the archives, and they were created to be a FOIA ombudsman office. And so if you really believe that the agency is being unreasonable, or just really think they've got the law wrong, or they're not understanding you, you can go to OGIS and they will try to facilitate, a meeting of the minds. So that is an option also. But unfortunately, sometimes none of this works, and you followed all of Mark's guidelines and you've written the perfect request, and it's narrow and it's specific and all of that. And you're still not, you can't get what you want or what you need, or you can't get the agency to respond. So then sometimes the only option you have is litigation. So let's talk about litigation. We can go to this is just a little fun beginning. So with litigation, there are some threshold issues. And I think Mark mentioned this in another context. One of the things that makes the FOIA such a useful tool is that it authorizes litigation, and that's not that common. So what the statute says is that if an agency has improperly withheld an agency record, courts have jurisdiction to hear those claims. Now, even though the statute is phrased in terms of improper withholding of agency records, it has been interpreted pretty broadly to include challenges to the adequacy of an agency search, to include challenges to a fee waiver denial. But I do have to say that I'm hearing about a movement by the government in some courts to argue that, in fact, the statute should be read very narrowly, and those kinds of challenges are simply not within the jurisdiction provision of the FOIA. And so we are going to be asking Congress to clarify that that is not at all what they meant. As Mark mentioned, it has to be an agency record, and they have to actually have possession and control of the record. This was an issue, I thought it would be a bigger issue at the time, when everyone was trying to get Hillary Clinton's emails from the server that she had, under her own control. And the courts did allow the FOIA requesters to get those records processed, but that generally an agency has to have possession and control. Now, a FOIA plaintiff, like all plaintiffs, has to show that they have standing, which for you non-lawyers, it's a constitutional requirement that just says, I have been injured in a way that's unique to me. I'm not asking the court for an advisory opinion. I have a real dispute and I need it resolved. And in the FOIA context, standing is really easy because all you have to do is say, I made a request and the agency didn't follow the law when they responded to my request. Now you can bring your lawsuit. You can always bring it in the District of Columbia. That's called the universal venue. But you can also bring it where you work or reside or where the records are. And Generally, courts apply a 6-year statute of limitations. And what this means is from the date at which your claim ripens, where you have a claim that you can now go into a court and bring a lawsuit, you have 6 years to bring that claim. Now, this last point is only partly true. I should have amended it because the FOIA, the statute itself spells a lot of this out, not the statute of limitations. And it says, it talks about what a court, the kind of relief that a court can order an award to a plaintiff. And it speaks in terms of requesters. So the US Court of Appeals for the DC Circuit, which is considered to be basically the key appellate court on FOIA issues, has said, given that language, that means that a court can only award relief to a requester. And so even if you're asking that there are certain proactive provisions there where agencies have to make certain information available, and the court said, I have no power to compel the agency to do anything but to make it available to you. But the Ninth Circuit Court of Appeals disagrees. So I think that's another issue that we will probably have to look to Congress to fix. And I say that because every few years, there's an opportunity to amend the statute. And our understanding is that there is some support in Congress for some FOIA reforms. So a lot of us in the access community have been thinking about what our wish list is for reforms. So let's go to the next slide. This is the other thing, you have to meet the requirements I just outlined, but you also have to do something called exhaust your administrative remedies. And what this is all about is when an agency, as under the FOIA, when they have an agency process that you have to go through, then you can't file a suit until you've gone through that process. And the idea is to give an agency time and opportunity to correct mistakes. Now, the way it works under the FOIA, as Mark mentioned, an agency has 20 business days to make a determination on your request. That time can be extended. But if an agency fails to comply with that time period, at the end of that time period, you can go directly to court. You don't have to do anything else, and you're considered to have constructively exhausted. You've met the requirement, you've waited. However, if you wait past that 20 or 30, whatever the extended time period is, and then maybe 2 months later, the agency finally responds and makes a determination on your request, then you have to go through the whole administrative appeal process if you're not happy with what the agency has said. And you have to file the appeal, and the agency has, I think it's 30 days to decide an appeal, and you have to wait that process out before you can go into court. I want to focus in on one thing. I talked about the amount of time that the agency has to make a determination, which is a real basic building block of the FOIA. And yet, until not that many years ago, there wasn't really uniform agreement on what a determination is. And I filed a FOIA request with the Federal Election Commission, and they kept telling me, oh, we're gonna get you something by X date, and that date would come and go, and we're working on it. And finally, I ran out of patience and I sued. And they argued in the district court that I had failed to exhaust administrative remedies because they'd made it, they'd told me they're working on my request, and that was good enough. And the court agreed, but we went to the DC Circuit and they disagreed, and they said, no, here's what an agency has to do during that period. An agency has to tell the requester what it's withholding and why, and what it's providing, and then has to promptly produce the records. So it's just an interesting thing how some of these terms that have been in the statute for decades, there isn't uniform agreement on what they mean. So we've talked about exhaustion, we've talked about the basic requirements of what you need, to have jurisdiction. Let's go to the next slide. Okay, so FOIA lawsuits are different from other civil litigation. And they're different in a couple key ways. The first is that the government, the defendant, has 30 days to file an answer to a complaint. So the complaint, of course, is the document that you file that sets out the facts of your lawsuit, the legal claims that you have. An answer is a document that the government files that responds specifically, paragraph by paragraph, to all of the claims that you've made in your complaint. They either admit them, they deny them, they say they don't know. And normally the government, unlike other parties, gets 60 days to file that answer. But Congress in the FOIA shortened that time to 30 days. And it did so because it believed that FOIA lawsuits should be expedited because of the critical need to get, timely access to information. I'll talk in a minute about whether that really works, but that is one way they're different. Another way that FOIA cases are different is the court exercises de novo review. And for those of you who are not lawyers, I'll try to explain it in as non-lawyer way as possible. But normally, when you bring a lawsuit and you're challenging an action of an agency, you've gone through some kind of agency process. Like in the FOIA, we talked about there's an administrative appeal process. The agency has made a decision, you're challenging that decision. And normally in those circumstances, the court can only look at the record that was before the agency when it made its decision. And it doesn't look at the whole case with fresh eyes, as it were. But FOIA cases are different, and a court does. And even though for exhausting administrative exhaustion requirements, you may have had to have gone through a FOIA administrative appeal, and there might be a record of that, and you put out why you think the agency is wrong, and the agency may have written a lengthy document that explains why they appropriately are withholding information. That doesn't matter. When you get into court, it's like you start all over. In fact, an agency can even raise new exemptions that they didn't raise below. And that also means that you can raise new grounds as to why the agency didn't meet the law that also were not raised below. So that's another way FOIA lawsuits are different. A third way, in some ways, this is kind of the most interesting. Normally, if you file a lawsuit as the plaintiff, you have the burden of proof, right? It's your lawsuit. You have to prove up your case. But in FOIA lawsuits, the burden of proof is actually on the agency. The burden shifts, and the agency needs to prove why it is that what they did complies with their obligations under the FOIA. And another way it's different is that it actually has a fee provision where if you have substantially prevailed in a FOIA lawsuit, you as a party can recover your fees and your attorney's fees and your litigation costs. And that, I will say, for nonprofit groups, is a real bonus. In the case I mentioned, where I had to sue the FEC over what does a determination mean, because they took us all the way up through the DC Court of Appeals. And keep in mind, this was a couple decades ago. We recovered, I think, like $165,000 in fees. So, it's not nothing. So let's go to the next slide. So what do these differences actually mean in practical terms? Well, I mentioned that the 30-day answer period was so that FOIA lawsuits would move more quickly, but the reality is very, very different. I am litigating a case now where we filed the lawsuit a couple of years ago. The FOIA request is a year older than that. We're still years away from a resolution. I mean, part of it is that I litigate in Washington, DC, and there are so many FOIA requests that are filed there. Again, as I mentioned, the pandemic has only added to the burden because agencies claim they don't have the same level of resources that they had pre-pandemic. The de novo review provision, as I mentioned, means that an agency can raise new exemptions and claims not raised administratively, and they can deviate from how they may have responded to your administrative appeal. The one exception on the de novo review, however, is for fee waiver and expedition issues. On those issues, the agency and a court, if you have to sue on that, can only look at the record that you make when you made the request for a fee waiver or for expedition. And that's why it's really important that you put in all the grounds that you have to justify why you're entitled to a fee waiver, and on expedition as well. And one thing Mark said that I really want to underline is that every agency for expedition has their own set of rules. And some of them are, most of them actually say at the end, you have to attest that what you're saying is true and correct to the best of your, to your knowledge. And if you leave that out, that alone would be a ground to deny your request. Now, while agencies bear the burden of proving why the exemptions they claimed were legitimate, the reality also is that courts give their declarations that they file to support their claims enormous deference. And they also are allowed to get away with hearsay testimony. Normally, that you can only testify to what you know, what you observed. But agency declarations will usually often be from one person, and they will go into, well, this is what we as an agency did. We sent this request to 5 different offices. Here's what each of those offices did. Here's what they withheld and why. Obviously, the person who's attesting to all this doesn't have firsthand knowledge, but they can get away with it in the FOIA context. And some of it's just administrative convenience. You don't want to have to get declarations from everybody, who had some role to play, but it can be really carried to extremes. And the example I would give you is I have a lawsuit now. You may recall when then Attorney General Barr publicly, I would say, described what was in the Mueller report, but misrepresented to the public what the Mueller report did and did not say, and why, in his view, it did not provide enough evidence of obstruction. He said that he was relying in part on an opinion from the Office of Legal Counsel. So we filed a FOIA request for that, and we're in litigation, and the agency is claiming deliberative process for some of the materials. And we've argued, well, that's ridiculous because there was no decision for the Attorney General to make, because under the special counsel rules, the decision was Mueller's about whether or not to indict. And there is a provision that if the Attorney General disagrees with the decision of the special counsel, the Attorney General is supposed to tell Congress. And in this case, the Attorney General Barr told Congress there were no instances when he disagreed with Mueller. And also he was bound by the DOJ rule that you can't indict a sitting president. So the point of this is that we were saying there was no decision to make, so it couldn't be subject to the deliberative process privilege. And they submitted a declaration from the head of the FOIA office that attested to the Attorney General's authority to make this decision. I think that's like patently absurd, but it just shows you sort of the extremes that agencies go to, and hopefully will not get away with here, to, in terms of presenting substantive arguments and declarations by people that are clearly not qualified. So let's go to the next slide. Okay, so here's how a typical FOIA lawsuit proceeds. I've talked about the complaint. The answer is the document that the government files response to the complaint. And in most cases, and when I talk about most cases, I'm talking about where the agency has actually withheld something. And you're fighting over whether or not the information is truly exempt. In most cases, they're decided on what are called cross motions for summary judgment. And these are, the government files its brief. Typically they go first because they have the burden of proof. And they lay out how and why they conducted an adequate search, and they justify their claimed exemptions. And it's a real challenge for a FOIA plaintiff because there's such an asymmetry to the access to information. We're in the dark, right? The government knows they made a decision about which offices were likely to have information. and responsive records. And we don't know if they overlook somebody or not often. They know what the documents hold. They know, they're making claims that the information is exempt, but we don't get to look at the information to see if their descriptions are accurate or not. And so it really, I think, even though Congress kind of tried to weight it to help the FOIA requester by saying the government has the burden of proof, the reality is that the government also has all the information, and they essentially control the factual record and what gets put before the court. And often all you can do as a FOIA plaintiff is challenge sort of the sufficiency of their facts and whether as a matter of law they've demonstrated that their exemption claims are proper. And so, it really is, it's difficult litigation in that respect, because even if you're well-versed in the law and understand the FOIA, the government still really sort of holds all the cards. And, there was an interesting case. I don't know, Mark, if you're probably familiar with it, because I think it was the New York Times, where they have a lawsuit where they're seeking from OMB information related to the whole, Ukraine aid. And the government had asserted deliberative process privilege over a group of documents. And the first time around, the court wasn't convinced they'd met their burden of proof. They submitted additional declarations. And the judge just ended up looking at some of the documents in camera, which means, privately, out, as the plaintiff doesn't get to participate in that process. And in an opinion, she denied some of the claims and said that when she looked at the documents, they did not match the description that the government had offered. And, looking at documents in camera like that is really the exception. And that really sort of sent a chill down my spine, because it made me wonder how many other cases does the government, either maybe not purposely, but their descriptions of the documents are not accurate. And we have no way, in this case, the only way we know that is because the judge looked at the records and said, wait a minute, what you've said these records are, that doesn't match up with what I looked at. So let's go to the next slide. So let me just kind of litigation. Oh, no, I'm sorry. This is the one I began with. So we can move on from here. Sorry. Yes, this is. So how do you maximize, with it being such a challenging event, litigation, how do you maximize your chances of success? Well, one thing I believe, and I tell others, and I'd be curious to see if Mark shares this, although I know as reporters, you often want to hold your cards to the vest. I think from the very beginning, when I file a FOIA request, I think about the story I'm telling. I mean, I work for nonprofits. They're asking for information, because they're trying to find out something about the government, and they think it's of interest to the public. So I start thinking from when I craft my FOIA, I put information in to tell the agency, but also to start telling the public why this information is important. And I carry that over to the litigation. When I'm writing a complaint, I go back, the first document I look at is the request, and I look at everything I put in there about the public importance of it. And the idea is I really want to get the court especially to appreciate that the information I'm trying to get is really important. And, that hopefully that will guide them in how they manage the case and how they consider the government's claims. I've talked about the fact that with the pandemic, agencies are so far behind. Quite often now, when I file a FOIA request, it's not because the agency has withheld information. It's because I can't even get them to process my request. And so typically what the litigation is about, at least in the early months, is just trying to come to a scheduling agreement on how fast they will be processed. And again, what I found, this is where if I can get the court to buy into my view that these documents are really in the public interest, it helps me, it might help me get a much more robust processing schedule. I think the only other thing I would add here that I haven't covered is in terms of maximizing your chance of success, look for ways, just as with a FOIA request, look for ways to narrow the issues in litigation, and then make sure the court knows that. You know, they know that, well, you've now eliminated the following documents, you know, are no longer challenging it. Again, it's a way to get some good faith going with the court. And then I think I'm on final thoughts, I believe. Yes. So the FOIA really is, at least in theory, it's a wonderful tool to find out what's going on behind the scenes. What did an agency do? When did it do it? Who was involved? Unfortunately, I mean, I think the good, bad, and ugly that Mark talked about is accurate. And I actually wrote a blog post not that long ago that talked about why the FOIA was essentially broken. I think that, especially he mentioned Exemption 5, which is, you know, deliberative process on discovery privileges. I call it the, you know, withhold because you can. And basically, you know, the government is blocking the very thing that the FOIA was intended to provide, which is a way to find out what our government is up to and why. In theory, though, it's a powerful tool. The fact that you have the ability to file a lawsuit is also a very powerful tool. And sometimes litigation, sadly, is the only option. And one sort of consequence of suing, especially if you're a frequent requester and a frequent litigant like I am and others are, is an agency knows that you're serious. And I actually think, you know, they know that if they can't reach an agreement with me, I'm probably going to sue them, and nobody likes to be sued. So I know we've used up a lot of time. I'm hoping we still have time for some questions.
Yeah, thanks a lot, Anne, and thank you, Mark. We have had a couple questions come in already, and I believe we go until 7:30, so we have time for questions. Feel free again to type in your questions into the Q&A or to raise your hand, and I can call on you that way. Our first question is a standing question, and a question about who can bring a suit after a request has been filed. So, imagine this hypothetical that a student is working on a research project and files a FOIA request, and then graduates or just moves on from the project. Can a professor or someone else then follow up and maybe even file a lawsuit?
I think that's difficult. It depends. For example, if the student filed the request on behalf of a clinic, then I think there's no question. So I am, for example, I am no longer at CREW, although I'm continuing to act as their outside counsel. I filed a bunch of FOIA requests, however, but they were on behalf of CREW. So it doesn't matter. CREW can still pursue litigation in those. It's a harder question, though, if you're asking for the request, you know, in your personal capacity, because the courts have basically held that somebody else can't stand in your shoes for purposes of filing a FOIA lawsuit. So I would, you know, if in fact, I mean, if for example, in your hypo, it were part of a clinic, I think the sound practice would be to make sure that you're making the request on behalf of the clinic. You know, if you're making the request on behalf of an entity. If you're doing it as a personal one, I think there is a likelihood that you will not be able to litigate on it.
Yeah, I've run into this problem a few times at the paper, to where most of the requests we file, will be for, an individual reporter who's looking for records or documents for a story that they're working on. So they'll write the request that, Mark Walker of the New York Times is seeking the following information. And we did get to a point where we wanted some information we wanted to get to from the State Department and wanted to try and file a lawsuit, but the State Department said that none of us basically had standing to file it. And in order to do that, we had to basically reach out to the person who filed the request, who was no longer at the Times. And basically, he had to call the State Department and give them permission to give ownership of the FOIA over to me. And then by giving it over to me and the Times, then we could move forward and file an appeal and do a lawsuit and things like that. But as long as they stayed in his name, they were his FOIAs. So there was nothing we can do. We had to sort of get his permission.
So was the problem there that in his initial FOIA, he didn't say, I am filing this on behalf of the Times?
Yes. So he was just saying, like, I am so-and-so, a reporter at the New York Times, and I'm seeking the following information. And he listed it. He, used, his, status as a reporter at the New York Times to get his fee waiver, talks about his reporting to make the expedited processing argument, but that's still, the agency can still consider like it his FOIA in general. Like it wasn't the New York Times's, it still belonged to him. So like the event that like he did leave the Times and he wanted to take his FOIA request with him, he would still be allowed to do that, and we wouldn't be able to sort of hijack that information.
All right, our next question is for Mark. What tools do you use to stay on top of all of the FOIA requests and all the deadlines and everything? What's your system for that?
I have a spreadsheet, sort of a Google spreadsheet. I had an example of it at the end of the presentation that we didn't get to, but it's in the slides if you want to see an example of it. But I'll have it in to where I'll have a column for, date filed, 20 days from now, a column that automatically produces like the 20-day deadline, the agency, the sub-agency, when I got a response, a description of it. So I have this spreadsheet that basically I just go in and check every day to see, when I filed something, what's the last response, where it is this one we're going to automatically litigate? So I don't need to pay a lot of attention to it outside of just looking for these prompts in my email. And so that's how I keep track of it. And I found it to be a fairly good system of tracking all the requests that I put in and file. There's sometimes I do these FOIA blitz where I will, put in FOIAs to 5-6 agencies or send public records requests to all 50 states. And I just use that spreadsheet to just keep track of who sent me records back, who hasn't responded, who's going to be rather difficult. So I know where to spend my time.
And then a question about state document requests. So we've been talking about FOIA, which is a federal statute. How do you access state document requests? And I guess if you could give us a quick overview of how similar or different various states statutes are from FOIA. And that could go to either of you, maybe Anne first.
Yeah, I love states' FOIAs, at least compared to the federal FOIA, for a couple of reasons. Number one, they're often broader. As you know, Congress is not subject to FOIA, but under state information laws, often the legislature is, along with, the governor and political offices, and often, institutions that get funding from the state are subject, like universities. So they're typically broader, and they don't have the same level of backlogs. And so you get documents, you actually get documents, you get them more quickly. I think Texas is the one that actually has a criminal proceeding, if you do a criminal penalty. The one downside I will note is a lot of them do not have provisions for fee waivers. So you often have to pay but my experience has been they are much better. And if I have an issue I'm interested in that there's a state angle, I know that I'm more likely to get something than I would if under the federal statute.
Yeah, some of the state laws, they can widely vary. I was a reporter in South Dakota where South Dakota might as well not have public records laws. That's how awful they are. You can be a victim of a crime and under their public records laws, you can't even get your own police report of the crime that was committed against you. So that's how awful they are. And then you can have places like Delaware, Arkansas, Alabama, states like that who have, and Tennessee who have these sort of like discretionary rules that if you put in something and they see it and it's like, oh man, this may make us look bad. They have a discretionary rule to say, you're not a requester from here. Doesn't look like you live in this state. So we're just going to deny you like out the gate and make sure like you're not going to get this information. Then, then you have the fee waivers to where, there's some states that have them, very few, but a lot of them who don't. Florida is great because they keep a lot of records, but they will charge you a lot of times a ton of money. I've had, a recent request where the sheriff's office in Miami called me and say, it might cost you over $200,000 to get this information. And I was like, yeah, I'm gonna call you back. I want to think about this, sit on this and figure out there's another way I can get it. There's other ways of they also open to negotiations, which what makes state FOIA requests like make your negotiation skills like really key, because you can always talk that price down if you're a good negotiator. And I often find it a lot faster than federal FOIA. We did an investigation in the beginning of the pandemic on the CDC's failures to address the COVID and how, the CDC allowed the virus to get into the country despite like its entire existence being created to deal with something like this. And when we were talking through, I was assigned to go get these records. I was like, you know what, everyone who's assigned to do this is going to go file FOIA requests with the CDC. And I was like, I'm going to file requests with all the states and all the state health departments and all the governor's office for their communications with the CDC. So if a lot of us are still waiting for records to come back for the CDC to produce their communications with the states, but I was able in a span of 2-3 months to collect 28,000 pages of records illustrating sort of the issues that were taking place just by going the state route. So it was a point I made in my slideshow about being creative of like using the FOIA law and using the public records kind of interchangeably creatively. I mean, it can be an incredible tool.
Yeah, that's a really good point about trying to think through how you might get the same information, but from a different source or a different angle. Maybe along the same lines, we have a question where, of course, you want to limit your request as narrowly as possible, make it as specific as possible. But if you don't know the titles of the actual documents you're looking for, you don't know that level of specificity. Are there any general tips for how to make your request more specific? Go to Mark first this time.
I would just try to get as close as possible. If you don't know maybe the particular name, sometimes I'll get descriptions. Like there'll be like an assessment of the risk of a terrorist attack here, or domestic terrorism, and I know there's a report that exists, but I may not know the specific name. I may say something like any assessments reports or memos put together about any risk DC poses to domestic terrorism, and I may throw like a time frame in there just so I narrow it down to any reports produced in a specific time period. If I can figure out who worked on the report or something like that, I would say the report was prepared by so-and-so, or the report may have been prepared ahead of this event, I try and be as descriptive as possible. And then using some of those other narrowing tools to like be broad but narrow at kind of at the same time.
Yeah, the only thing I would add is really to reiterate something that Mark said earlier, which is do your homework. I mean, I really think before you file a FOIA request, you do as much research as you can on the topic, but also look at the agency reading rooms. What have they already posted? What does the agency already make available online? I typically look at news stories on a topic and see, like what's already been reported, and is there some suggestion in there? Maybe there's a document that they obviously had that they haven't made public that I want. So really do your homework. But sometimes, you're left with just, the best you can do is a description and a time frame and maybe a suggestion of which offices to be searched, and if you can get it out to specific individuals.
So our next question is about avoiding requests that are too broad. And it's, is it acceptable? Do agencies mind if you send multiple requests that are each narrow and replace a much broader request that the agency might have more concerns about?
I do know there's a provision in the FOIA that says you can't break your request down into multiple subparts in order to avoid some of the rules and all. I have to say, I don't typically do requests that are complicated enough where I think about it in terms of breaking it down like that. So maybe Mark, you can speak to that. I don't know if you've had that experience.
Depending on how broad we decide to go, I mean, that's just usually something we go into knowing that we're going to have to litigate. Because it's like we've had examples of requests where we say, hey, I want all emails sent to and from these 5 people for like a year or 2 span. Like as soon as the agency sees that, they're going to pick up the phone and call me and say, yeah, we're not doing that. And it's like, they can't say they're not doing it. They still have to do it, but like, they're going to try everything and try and find every reason why they don't have to do it. Maybe they say, I'm being too broad and burdensome, or in things like that, which isn't really a like legal excuse for why you're not doing it. It's like, hey, like, I know this is a lot of records, but then that's usually where, like, if we are going to go into litigation, we'll go and we'll talk, and then we'll probably end up narrowing it down to sort of like, I only want sent emails with like complete email chains. And then we cut through a bunch of the fodder that otherwise we would get, maybe add some keywords in. We have currently a lawsuit against Department of Treasury, and we talked about it, and we've come up, we looked at spreadsheets, we got domain names, and it just seemed, and work with Charles with this, and it just seemed that, and he can speak to, like, there's nothing we can do to make them produce the set of documents. And sometimes you run into that, but you can try and you can fight and you can negotiate and you can try and narrow it as much as possible. There have been some instances where the Sierra Club has gotten EPA and Interior to produce these sort of massive rolling responses, which is what it ended up getting former Secretary Pruitt out of office. Is some of the documents that they got back. But again, it's the judge, it's how you wrote the FOIA, how much the agency is willing to fight you. A lot of factors play into that.
If I could just add one caution that I should have mentioned, one of the things that I'm seeing increasingly, because agencies are overwhelmed, they're really quick to label your request overbroad. Do not take that response at face value, because they look at it and they just think, oh, it's more work, I don't want to do it. And they say overbroad. And maybe there's some percentage of people that go away. but, really don't take it at face value. The other thing that I hear from agencies that drives me insane, we typically want email communications, and they'll say, well, you have to give us, the people's whose email accounts you want searched. Well, if I knew that, I know a lot more about this topic than I do now, but in any event, they have the ability, I am not a technically savvy person, and I know I can type in a name or a subject and go through my email and cull out what will be responsive. So agencies have become very creative at finding ways to deem your request not perfected, which means that if they deem it not perfected, it's as if it were never filed and they're free to ignore it.
So if the agency does come back to you and say request is overbroad, what's the first step you take to address that? And I guess relatedly, what sorts of strategies do you use to negotiate with the agency, maybe narrow the request? How do you approach that sort of situation?
Well, what I do, it starts with having a conversation, because a lot of times when I talk to them, it may not even be the person who told me my request was overbroad. I really, I welcome the opportunity to talk to the agency FOIA people, because a lot of times they'll say, well, your request, you may not have realized, but as drafted, this is what you're going to get back. Is that what you want? And it's like, no, that's not what I want. So they can help you. They can tell you where, if you can help them understand what you want, they can help you figure out where it actually is. So I think just having those kinds of conversations, but a lot of times we're just met with just sort of patently unreasonable people. And we try to compromise, if they say, well, we need domain names, we'll say, well, if we want communications with the White House, so they want specific domain names. So the best we can do is, anything within eop.gov. But it really depends. There's some great FOIA people out there at agencies who are helpful and who want to work with you, and they're not opposed to disclosure. And then there are some others that are more difficult. I'm sure you have some great advice since you deal with them so much more frequently.
I usually have a blanketed response sort of written up of yeah, this is not a thing. I'm happy to talk about this. Here's every contact number and email that I exist. Let's hop on the phone and sort of talk this through. And a lot of it, it's some of it's just really unreasonable. I talked to FOIA officers, there's going to be 1,000 responsive records. That's just so many. And I'm just sitting on the other end of the phone of no, it's not. It's because you're not going to give me 1,000. You may have 1,000 to look through, but I may get 17 of those 1,000. So no, that's not really what's going on here. And I just sort of talk them through, and I'm hey, I'm looking for this information. I don't want to make your life harder than it already is. I also don't want you to make my life really hard. What can we do to get this through? If there's something I'm missing, it's something that I'm not seeing. Sometimes it's just somebody may say, I'm just understaffed. I'm just one person. And I will say, okay, let's talk about this. Maybe we can narrow it. How about we do a rolling release? And it's if we go to court and, get through, you're going to be put on the production schedule anyway, and you're going to produce these documents. How about if there's so many, we may just kind of make a verbal agreement that you just give me several hundred every month, and that's worked out. And that's pretty much it. But sometimes there honestly is just people who don't want to work with you. I had a guy once who was oh, I'm going to call you tomorrow. And then I didn't hear from him for 5 months. And then I end up calling the agency, finally got someone who's oh man, he had kidney surgery. He had a kidney replacement. And I'm he knew he wasn't going to speak to me, and I wasn't going to speak to him anytime soon. So he was I've got surgery. I'm out. And he just left and there was nothing I can do. And that's just kind of how it is sometimes. And it's just, you win some, you lose some, and that's why you have to go the litigation route sometimes.
So we have a couple legal related questions. The first is about deadlines. If somebody misses a deadline, maybe to file a lawsuit or a deadline within the lawsuit, is there anything they can do? Can they refile their original FOIA request and restart the clock that way? So that's one legal related question. Then the other, because we're getting a little short on time, is about attorney's fees. What are some of the considerations when requesting fees? What do the courts look for when they're deciding whether a fee request is reasonable? And how does that process work?
So on the first question, I'm not sure I fully understand the situation, but if it is a situation that maybe because you missed a deadline, your case got dismissed, yes, you can always file a new FOIA request. So that's certainly something to think about. Otherwise, you just have to throw yourself on the mercy of the court, basically. But unless, you know, you lose a case and you get a judgment against you and the court rules that the information is exempt, you can always go back and file a new FOIA request. On the fee provisions, the way the statute works is if you can show that you substantially prevailed, you're entitled to get your fees and your costs. And typically courts apply what's sort of a catalyst theory, which is if you can show some connection between the litigation and a result, a win, you can get fees. Even if you can't get fees for everything you did in the case, you may be able to get fees for portions. So for example, because so much of litigation these days is working out production schedules, if you file a lawsuit and the judge issues an order and says the parties have to meet and confer, and I want you to issue, you know, a scheduling, processing schedule and a date for filing briefs, etc. So you get a processing schedule. If you can get the court to commit it to an order, you have a legitimate argument that you've prevailed. You got something from that litigation. You got documents processed, and you can recover your fees for that part of the case. And that's another thing, you know, you may not be able to recover fees for everything. You can't get fees for anything you did at the administrative level. But, you know, the problem with fees is that FOIA litigation takes so long. So, you know, if you go into it thinking, oh, you know, I can have a nice FOIA business because I'll get my fees. Yeah, you might, but it may be 5 or 6 years down the road. But, you know, the other thing to know about fees is that for many of us, especially like in the nonprofit arena, we don't have hourly fees. So the court uses something called a laughing matrix, which is set each state, and it's basically it's sort of a compendium. They feed a lot of information into it about what a lot of different lawyers in your area charge. So when I get fees under FOIA, I'm compensated at a very generous rate. Nothing that I would ever charge any of my clients, you know, because I have it's based on years of experience and it's based on your geographic location. So, you know, often the fee aspect of a case is its own litigation because the government often resists paying. And so you have to litigate, and then you get what's called fees on fees. If you win, you also get compensated for the time you spent having to litigate your entitlement. But basically you have to show that you substantially prevailed and that, you know, you caused something to happen that wouldn't have happened but for your litigation.
So next we have a question from somebody who describes themselves as FOIA curious, somebody without much experience with FOIA, and this might need to be our last question, depending on time. But they ask whether there are any organizations they could partner with in filing a request, organizations that might lend them an air of credibility or give them additional resources that could help them create the request and then pursue it after they file. Are there any organizations like that that first-time requesters can look to for help and guidance?
I'm not sure I know of any per se. I mean, certainly Crew gets approached not infrequently with individual requesters wanting us to do something on their behalf, and that we're really not set up to do that. On the other hand, there are resources. The Reporters Committee for Freedom of the Press has a really good FOIA resource. Actually, the Department of Justice puts out a handbook on FOIA. And while I don't always agree with their assessment of what a lawsuit, or what a court holding was, it's pretty comprehensive and lays it out. So if you're trying to get the lay of the land, and then there is an organization called the American Society of Access Professionals, and they do trainings, and some other groups probably do trainings as well. So that's one way, but I have certainly helped other organizations that don't have any FOIA experience figure out, how to craft a FOIA. But I don't know what resources there might be. I don't know if Mark does.
Those were all the resources I could think of as well.
Well, we are about out of time, so I'd just like to thank both of you for joining us tonight. We really appreciate your time, and I think this has been a helpful event. And thank everyone else for joining us tonight. We appreciate you coming on a Wednesday evening. So I hope you all have a nice evening, and thanks again.